it's my conclusion. Sure, it's my conclusion, but I'm reporting what the team thought and their supervisors. As I said, this was, as painful as it is for people sometimes, this was not a close call. I think questions are fair. I think criticism is healthy and fair. I think reasonable people can disagree about whether I should have announced it and how I should have done it. What's not fair is any implication that the Bureau acted in any way other than independently, competently, and honestly here. That's just not true. I knew this was going to be controversial. I knew there'd be all kinds of rocks thrown. But this organization and the people who did this are honest, independent people. We do not carry water for one side or the other. That's hard for people to see because so much of our country we see things through sides. We are not on anybody's side. This was done exactly the way you would want it to be done. That said, questions are fair. Feedback is fair.
Absolutely. But the foot soldiers, we use that term in the civil rights movement, your agents on the ground, you take issue with whether or not they were compromised or they were adhering to somebody else's message. Is that what you're saying?
Absolutely. You can call us wrong, but don't call us weasels. We are not weasels. We are honest people, and we did this in that way. Whether you disagree or agree with the result, this was done the way you would want it to be done.
Chair thanks the gentlewoman. Recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Well, thank you, Mr. Chairman. I want to start by acknowledging progress. I think it's important that we do so. This morning, we've had 9 straight Democrats talk to the FBI about emails without asking for immunity. That's a record. And I suspect the reason that they have not asked for immunity from Director Comey is they would say they've done nothing wrong. I find that interesting because that's exactly what Heather Samuelson and Cheryl Mills' attorneys said. In fact, they said it just a few days ago, and I'll quote it. The FBI considered my clients to be witnesses and nothing more. And then Ms. Mills and Ms. Samuelson's attorney said this. I think this is the most interesting part. The Justice Department assured us my clients did nothing wrong. Well, Mr. Chairman, if you're assuring subjects or targets or what witnesses, whatever you want to call them, that they've done nothing wrong, it does beg the question, what are you seeking and receiving immunity from? I mean, if you've done nothing wrong, laptops don't go to the Bureau of Prisons, Mr. Chairman. People do. So the immunity was not for the laptop. The immunity was for Cheryl Mills. And if the Department of Justice says you've done nothing wrong, it does beg the question of why you are seeking or receiving immunity. And it could be, Mr. Chairman, for a couple of different, it could be for the classified information that was the genesis of the investigation. It could be for the destruction of federal records, which came from that initial investigation, or it could be both. Mr. Comey, I want to ask you this. Did the Bureau interview everyone who originated an email that ultimately went to Secretary Clinton that contained classified information?
I don't think so. Nearly everyone, but not everyone.
Well, you and I had a discussion the last time about intent. You and I see the statute differently. My opinion doesn't matter. Yours does. You're the head of the Bureau. But in my judgment, you read an element into the statute that does not appear on the face of the statute. And then we had a discussion about intent. So why would you not interview the originator of the email to, number one, determine whether or not that originator had a conversation with the secretary herself?
There were a handful of people who the team decided it wasn't a smart use of resources to track down. One was a civilian in Japan, as I recall, who had forwarded something that somehow got classified as it went up. And the other were a group of low-level State Department people deployed around the world who had written things that ended up being classified. Nearly everyone was interviewed, but there was a small group that the team decided it isn't worth the resources.
Well, to that extent, if you interviewed the overwhelming majority of the originators of the email, will you make those 302s available to Congress? Because I counted this morning 30-something 302s that we do not have.
Okay. I'll go back and check. My goal is maximum transparency, consistent with our obligations under the law. I'll check on that.
Well, and I appreciate it. For this reason, intent is awfully hard to prove. Mm-hmm. Very rarely do defendants announce ahead of time, I intend to commit this crime on this date. Go ahead and check the code section. I'm going to do it. That rarely happens. So you have to prove it by circumstantial evidence. such as whether or not the person intended to set up an email system outside the State Department, such as whether or not the person knew or should have known that his or her job involved handling classified information, whether or not the person was truthful about the use of multiple devices, whether or not the person knew that a frequent emailer to her had been hacked, and whether she took any remedial steps after being put on notice that your email or someone who's been emailing with you prolifically had been hacked. And whether or not, and I think you would agree with this, Director, false exculpatory statements are gold in a courtroom. I would rather have a false exculpatory statement than a confession. I would rather have someone lie about something and it be provable that that is a lie, such as that I neither sent nor received classified information, such as that I turned over all of my work-related emails. All of that, to me, goes to the issue of intent. So I got two more questions, then I'm going to be out of time. For those who may have to prosecute these cases in the future, what would she have had to do to warrant your recommendation of a prosecution? If all of that was not enough, because all of that's what she did, if all of that's not enough, I mean, surely you cannot be arguing that you have to have an intent to harm the United States to be subject to this prosecution. I mean, that's treason. That's not a violation of this statute.
No, I think we'd have to be able to prove beyond a reasonable doubt a general awareness of the unlawfulness of your conduct. You knew you were doing something you shouldn't do. And then, obviously, that's on the face of the statute itself. Then you need to consider, so who else has been prosecuted and what circumstances, because it's all about prosecutorial judgment. But those two things would be the key questions. Can you prove that the person knew they were doing something they shouldn't do, a general criminal intent, general mens rea,
but the
and
way
have
to
treated
prove,
other people similarly?
The way to prove that is whether or not someone took steps to conceal or destroy what they've done. That is the best evidence you have, that they knew it was wrong, that they lied about it.
It's very good evidence. Always want to look at what the subject said about their conduct.
Well, and there's a lot. There's a lot. If you saw her initial press conference, it all falls under the heading of false exculpatory statement. I'm out of time, Mr. Chairman, but the director did. You started off by giving us examples of things the Bureau has done. And every one of us who's worked with the FBI, that is the FBI that I know. The one that went and saved that girl in North Carolina, that is the FBI that I know. What concerns me, Director, is when you have 5 immunity agreements and no prosecution, when you are allowing witnesses who happen to be lawyers, who happen to be targets, to sit in on an interview. That is not the FBI that I used to work with. So I've been really careful to not criticize you. In fact, I said it again this morning. They wanted to know, was he gotten to? Did somebody corrupt him? No, I just disagree with you. But it's really important to me that the FBI be respected. And you got to help us understand, because it looks to me like some things were done differently that I don't recall being done back when I used to work with them. And with that, I would yield back to the chairman.
Can I respond to that?
Flynn and others' name from classified documents and leak them to the press.
Do you know whether Director Clapper knew the name of the U.S. citizen that appeared in the New York Times and Washington Post?
I can't say in this forum because, again, I don't want to confirm that there was classified information in the newspaper.
Would he have access to an unmasked name?
In some circumstances, sure.
Would Director Brennan have access to an unmasked U.S. citizen's name?
In some circumstances, yes.
Would former White House advisor Ben Rhodes have access to an unmasked U.S. citizen's name?
I don't know the answer to that.
Could you find out? South Carolina Congressman Trey Gowdy is joining us right now from Washington. He's a member of the House Permanent Select Committee on Intelligence, which is why he got in the door with his special pass and was able to ask those questions. Congressman, why were you running down those lists of Obama officials?
Well, I started, Brian, with the NSA, and the testimony was there were 20 folks there. And in a previous conversation with Director Comey, not yesterday, we identified the universe of people at the FBI. So I'm trying to find that discrete universe of people who had access to the name. You and I are not on that list. So that will save the FBI the trouble of coming and interviewing you and interviewing me. but I'm trying to help the public and Director Comey kind of narrow down the universe of people who would have had access to the information to then leak it.
When he came out and made his initial, after you guys made your speeches, after Devin Nunes came out and Congressman Schiff came out and made their opening remarks, he was asked, you know, why, basically, what are your remarks? I want to confirm that there's an investigation going on to the role of Russia in the last election and any type of relationship with the Trump organization. Was that new news to you?
It was not. It should not have been new news to anyone on House Intel. Again, the beauty of Intel is we do our work behind closed doors, and you have access to information that perhaps other members don't have. You just can't talk about it. So that was not a surprise to me.
So what did we learn from yesterday? What did Trey Gowdy, the prosecutor, learn from yesterday?
I learned it's really tough to run serious quasi-criminal or criminal investigations in a public setting, which is why it's never done, except in Washington. I think the most troubling part for me was when Director Comey would not assure us that there's a leak investigation. He was more than happy to assure us that there's an investigation into the potential ties between the Trump campaign and Russia, which may or may not be a crime. Leaking of classified information is a crime, but he would not confirm that investigation.
Would you also, are you surprised that there's no interest in John Podesta's perhaps investment in a company that Vladimir Putin was invested in that was turned over to his daughter? I think John Podesta played a major role.
You know, I don't know, and I'm not supposed to know, and I hope the FBI is working on lots and lots of things involved in this fact pattern that no one knows about, because that's a sign to me of the integrity of the investigation. But I have no idea what Director Comey knows and what the women and men of the FBI are working on.
What about the fact that Roger Stone and some others, Paul Manafort and others, were somehow in contact with Russians? And they might deny it, but in Roger Stone's case, he direct tweeted Guccifer. He was praising Julian Assange. Is that what do you think? What role do you think they played with Trump? What role do you think they played in this entire thing, from what you can tell us?
Don't know, and won't be able to answer that question until the Bureau interviews the names you just mentioned. There are times in life where people claim to have a connection or a nexus with folks, and that is not borne out factually. You will never hear me compliment Julian Assange or WikiLeaks. And I'm disappointed in anyone who does. But the FBI has access to far more information even than House Intel, and they're pursuing an investigation. And what I told him at the end yesterday, Brian, is there's a vacuum right now, and politicians will fill that vacuum. So the sooner you conclude your investigation, the better it is for the American people.
And finally, I know I'm up against a hard break and you have to run, but when do you think this will be done from your professional standpoint after we saw prior investigations? We're going to month, weeks?
You know, yesterday I commented to Chairman Nunes that it only took 8 days to go through all of Secretary Clinton's emails between the first letter and the second letter. I hope, and I'm sure Director Comey knows the gravity of this investigation from a constitutional perspective, and I'm sure they would do it as quickly as possible, but it depends upon the evidence and the number of witnesses and the number of documents.
Somehow, if there's a big story in Washington, Congressman Trey Gowdy's in the middle of it. So thanks so much for joining us.
Yes,
I appreciate it.
Yes, sir. Thank you.
All right.
Chairman, Director Comey, we will begin this line of questioning, then we'll finish it the next round. FISA and other similar related counterterrorism programs have been described even this morning as vital, critical, and indispensable to our national security. And many of us on both sides of the aisle believe FISA and similar counterterrorism programs prevent terrorist attacks and save American lives. But FISA and other surveillance programs are intentionally designed to preserve the privacy of U.S. citizens. They are intentionally designed to ensure the information is collected and used only for legitimate national security and criminal investigative purposes. There are statutory safeguards. There are warrants based on probable cause. There is a FISA court that is involved. There are audits on the back end, and we think so highly of this material. It is a felony punishable by up to 10 years in federal prison to unlawfully disseminate it. All of this was done to make sure this information gathered remains protected as it relates to U.S. citizens. The way I view it, Director Comey, the American people have an agreement with their government. We are going to give you the tools to keep us safe, even if it infringes on our privacy some. We're going to give you the tools. And government in return promises to safeguard the privacy of U.S. citizens. And when that deal is broken, it jeopardizes American trust in these surveillance programs. So let me ask you, do you agree FISA is critical to our national security?
I do.
Do you agree programs like FISA were intentionally designed to safeguard the identity of U.S. persons?
Yes, there are other important elements of it, but that's the primary goal, I believe.
It wasn't an afterthought. It wasn't an accident. These are intentional safeguards that we put in place to protect U.S. citizens. Is that correct?
Correct.
Do you agree much of what is learned from these programs is classified or otherwise legally protected?
All FISA applications, review by the court, collection by us pursuant to our FISA authority is classified.
The dissemination of which is a felony punishable by up to 10 years in prison?
Sure, dissemination, unauthorized dissemination.
Unauthorized dissemination of classified or otherwise legally protected material punishable by a felony up to 10 years in federal prison.
Yep, yes, as it should be.
All right. In January of this year, the Washington Post reported, according to a senior U.S. government official, a named U.S. citizen, and I will not use the name, a named U.S. citizen, phoned the Russian ambassador several times on December the 29th. In February of this year, the Washington Post reported nine current and former officials who were in senior positions at multiple agencies at the time of the call spoke on the condition of anonymity to discuss intelligence matters, and that officials began poring over intelligence reports, intercepted communications, and diplomatic cables. In February of this year, the New York Times reported a U.S. citizen, whose name I will not use, discusses sanctions with the Russian ambassador in a phone call, according to officials who have seen a transcript of the wire-tapped conversation. And again in February of this year, the New York Times reported on a phone call involving a U.S. citizen, including significant discussions of phone records, intercepted calls, intercepted communications, and reported the NSA captured calls and then asked the FBI to collect as much information as possible. My time is up, so I will say this for this round. I thought it was against the law to disseminate classified information. Is it?
Oh, yes, sure, it's a serious crime. I'm not going to comment on those particular articles because I don't want to, in any circumstance, compound a criminal act by confirming that it was classified information. But in general, yes, it's a serious crime, and it should be, for the reasons you said.
We'll take it back up next round, Mr. Chairman. Gentleman yields back. Director Comey, you and I were discussing the felonious dissemination of classified material during the last round. Is there an exception in the law for current or former U.S. officials who request anonymity?
To release classified information?
Yes, sir.
No.
Is there an exception in the law for reporters who want to break a story?
Well, that's a harder question as to whether a reporter incurs criminal liability by publishing classified information, and one probably beyond my ken. I'm not as good a lawyer as Mr. Schiff said I used to be.
Well, I don't know about that, but the statute does use the word publish, doesn't it?
It does, but that's a question I know the Department of Justice has struggled with through administration after administration.
I know the Department struggled with it, the Fourth Circuit struggled with it, lots of people have struggled with it, but you're not aware of an exception in the current dissemination of classified information statute that carves out an exception for reporters.
No, I'm not aware of anything carved out in the statute. I don't think a reporter's been prosecuted, certainly in my lifetime, though.
Well, there have been a lot of statutes at bar in this investigation for which no one's ever been prosecuted or convicted, and that does not keep people from discussing those statutes, namely the Logan Act. In theory, how would reporters know a U.S. citizen made a telephone call to an agent of foreign power?
How would they know legally?
Yes.
If it was declassified and then discussed in a judicial proceeding or a congressional hearing, something like that.
And assume none of those facts are at play, how would they know?
Someone told them who shouldn't have told them.
How would a reporter know about the existence of intercepted phone calls?
Well, same thing. In a legitimate way, through a appropriate proceeding where there's been declassification. In any other way, in an illegitimate way.
How would reporters know if a transcript existed of an intercepted communication?
Same answer. The only legitimate way would be through a proceeding, appropriate proceeding. The illegitimate way would be somebody told them who shouldn't have told them.
What does the term mask mean in the concept of FISA and other surveillance programs?
As Director Rogers explained, it's our practice, approved by the FISA court, of removing the names of U.S. persons to protect their privacy and their identity unless it hits certain exceptions. So masking means, as Mike Rogers said, I'll often see an intelligence report from NSA that will say U.S. person number 1, U.S. person number 2, U.S. person number 3, and there's no further identification on the document.
Admiral Rogers said there are 20 people within the NSA that are part of the unmasking process. How many people within the FBI are part of the unmasking process?
I don't know for sure as I sit here. Surely more, given the nature of the FBI's work. We come into contact with U.S. persons a whole lot more than the NSA does because we may be conducting, we only conduct our operations in the United States to collect electronic surveillance, to conduct electronic surveillance. So I can find out the exact number. I don't know it as I sit here.
Well, I think, Director Comey, given the fact that you and I agree this is critical, vital, indispensable, a similar program is coming up for reauthorization this fall with a pretty strong headwind right now. It would be nice to know the universe of people who have the power to unmask a U.S. citizen's name, because that might provide something of a roadmap to investigate who might have actually disseminated a masked U.S. citizen's name.
Sure, the number is relevant, but what I hope the American people will realize is the number is important, but the culture behind it is, in fact, more important. The training, the rigor, the discipline. We are obsessive about FISA and the FBI for reasons I hope make sense to this committee, but everything that's FISA has to be labeled in such a way to warn people, this is FISA. We treat this in a special way. So we can get you the number, but I want to assure you the culture of the FBI and the NSA around how we treat U.S. person information is obsessive, and I mean that in a good way.
Director Comey, I am not arguing with you, and I do agree the culture is important. But if there are 100 people who have the ability to unmask and the knowledge of a previously masked name, and that's 100 different potential sources of investigation. And the smaller the number is, the easier your investigation is. So the number is relevant. I concede the culture is relevant. NSA, FBI, what other U.S. government agencies have the authority to unmask a U.S. citizen's name?
Well, I think all agencies that collect information pursuant to FISA have what are called standard minimization procedures, which are approved by the FISA court that govern how they will treat U.S. person information. So I know the NSA does, I know the CIA does, obviously the FBI does. I don't know for sure beyond that.
How about the Department of how about Maine Justice?
I mean, Maine Justice, I think, does have standard minimization procedures.
All right, so that's 4. The NSA, FBI, CIA, Maine Justice. Does the White House have the authority to unmask a U.S. citizen's name?
I think other elements of the government that are consumers of our products can ask the collectors to unmask. The unmasking resides with those who collected the information. And so if Mike Rogers' folks collected something and they send it to me in a report and it says U.S. person number 1 and it's important for the FBI to know who that is, our request will go back to them. The White House can make similar requests of the FBI or of NSA, but they don't on their own collect, and so they can't on their own unmask. I got that about right?
that's
yeah.
I guess what I'm getting at, Director Comey, is you say it's vital, you say it's critical, you say it's indispensable. We both know it's a threat to the reauthorization of 702 later on this fall. And, oh, by the way, it's also a felony punishable by up to 10 years. So how would you begin your investigation, assuming for the sake of argument that a U.S. citizen's name appeared in the Washington Post and the New York Times unlawfully? Where would you begin that investigation?
Well, I'm not going to talk about any particular investigation.
That's why I said in theory.
You would still figure out, so who are the suspects? Who touched the information that you've concluded ended up unlawfully in the newspaper, and start with that universe, and then use investigative tools and techniques to see if you can eliminate people or include people as more serious suspects.
Do you know whether Director Clapper knew the name of the U.S. citizen that appeared in the New York Times and Washington Post?
I can't say in this forum because, again, I don't want to confirm that there was classified information in the newspaper.
Would he have access to an unmasked name?
In some circumstances, sure. He was the Director of National Intelligence, but I'm not talking about the particular.
Would Director Brennan have access to an unmasked U.S. citizen's name?
In some circumstances, yes.
Would National Security Advisor Susan Rice have access to an unmasked U.S. citizen's name?
I think yes, in general, and any other national security advisor would, I think, as a matter of their ordinary course of their business.
Would former White House advisor Ben Rhodes have access to an unmasked U.S. citizen's name?
I don't know the answer to that.
Would former Attorney General Loretta Lynch have access to an unmasked U.S. citizen's name?
In general, yes, as would any Attorney General.
So that would also include acting AG Sally Yates?
Same answer.
Did you brief President Obama on, well, I'll just ask you, did you brief President Obama on any calls involving Michael Flynn?
I'm not going to get into either that particular case, that matter, or any conversations I had with the President, so I can't answer that.
Well, Director Comey, there's been some speculation this morning on motive. I'm not all that interested in motive. First of all, it's really hard to prove. Secondarily, you never have to prove it. But I get that people want to know. The jury always wants to know why. I think you and I can agree there are a couple of reasons that you would not have to unlawfully, feloniously disseminate classified material. It certainly wasn't done to help an ongoing criminal investigation because you already had the information, didn't you?
Again, I can't answer in the context of this particular matter.
How about in theory? Is there something a reporter would have access to that the head of the FBI would not?
It's hard for me to answer. I would hope not when it relates to the
I would
FBI's
hope not, too, since it's part of our surveillance programs. I would hope that you had access to everything as the head of the world's premier law enforcement agency. I would hope that you had it all. So if you had it all, the motive couldn't have been to help you because you already had it. And Admiral Rogers, the motive couldn't have been to help you because you already had it. So in the universe of possible motives for the felonious dissemination of classified material, we could rule out wanting to help the intelligence communities and the law enforcement communities. Those are two motives that are gone now. That leaves some more nefarious motives. Is the investigation into the leak of classified information, has it begun yet?
I can't say because I don't want to confirm that that was classified information.
Well, I don't want to quarrel with you, Director Comey, and I do understand that you cannot ordinarily confirm or deny the existence of an investigation. But you did it this morning citing DOJ policy given the gravity of the fact pattern. Would you not agree that surveillance programs that are critical, indispensable, vital to our national security, some of which are up for reauthorization this fall, that save American lives and prevent terrorist attacks also rises to the level of importance?
I think those programs are vital, and leaks of information collected pursuant to court order under those programs are terrible, and as I said in my opening statement, should be taken very, very seriously. What I don't ever want to do is compound what bad people have done and confirm something that's in the newspaper, because sometimes the newspaper gets it right. There's a whole lot of wrong information allegedly about classified activities that's in the newspaper. We don't call them and correct them either. That's another big challenge, but we just don't go anywhere near it because we don't want to help and compound the offense that was committed.
I understand that, Director Comey, and I'm trying really hard not to get you to discuss the facts at bar. But some of the words that appeared in this public reporting include the word transcript, which has a very unique use in the matters that you and I are discussing this morning. That is a very unique use of that word. Wiretap has a very specific meaning. The name of a U.S. citizen that was supposed to statutorily be protected is no longer protected. So some of this reporting, let's assume 90% of it is inaccurate. That other 10% is still really, really important. And to the extent that you can rely on the dates in either the Washington Post or the New York Times, we are talking about February of this year is when the reporting first took place. So we're a month and a half or 2 months into something that you and I agree is incredibly important and also happens to be a felony. So I'm just simply asking you to assure the American people, you've already assured them you take it really seriously. Can you assure them that it is going to be investigated?
I can't, but I hope people watching know how seriously we take leaks of classified information, but I don't want to confirm it by saying that we're investigating it. And I'm sorry I have to draw that line. I just think that's the right way to be.
Well, I'm not going to argue with you, Director Comey, but it is, we're going to discuss a lot of important things today. Whether Russia attempted to influence our democratic process is incredibly important. Whether they sought to influence it is a separate analysis, incredibly important. The motive behind that interference and influence, incredibly important. Our U.S. response, incredibly important. Some of that may rise to the level of a crime. Some of it does not rise to the level of crime. One thing you and I agree on is the felonious dissemination of classified material most definitely is a crime. So I would ask you, and I understand some of the procedures that you are up against, I would humbly ask you to seek authority from whomever you need to seek authority from. Because I'm going to finish the same way I started. This is an agreement between the American people and its government. We, the American people, give certain powers to government to keep us safe. And when those powers are misused, and the motive is not criminal investigations or national security, then I'll bet you my fellow citizens are rethinking their side of the equation. Because that U.S. citizen could be them next time. It could be you. It could be me. It could be anyone until we start seriously investigating and prosecuting what Congress thought was serious enough to attach a 10-year felony to. With that, I would yield back, Mr. Chairman.
Can I just add a response to what you said? I agree with you, Mr. Gowdy. Two things folks at home should know. First, an unauthorized disclosure of FISA is an extraordinarily unusual event, so be assured we're going to take it very seriously because our trust with the American people and the federal judges that oversee our work is vital. And second, that this conversation has nothing to do with 702. Folks often mix them together. 702 is about targeting non-U.S. persons overseas. Pursuant to the FISA statute, the FBI can apply to collect electronic surveillance in the United States, but it's a different thing from 702. The conversation you and I are just having is about this, which is vital and important, but I just didn't want to leave folks confused.
Director Comey, you are 100% correct, and I am 100% correct in saying that that is a distinction that doesn't make a difference to most of the people watching television. You are exactly correct. What we are reauthorizing this fall has nothing to do with what we are discussing other than it is another government program where the people consent to allow government to pursue certain things with the explicit promise it will be protected. So you're right, they're different. But in the eyes of people watching, it is the U.S. government officials leaking the name of a U.S. citizen, and if it can happen here, it may happen there. Trust me, you and I both want to see it reauthorized. It is in jeopardy if we don't get this result.
Are you still seeking a one-week delay in order to testify?
On the advice of my counsel, I respectfully exercise my Fifth Amendment right and decline to answer that question.
Ladies and gentlemen, seeking the truth is the obligation of this committee. I can see no point in going further. I have no expectation that Ms. Lerner will cooperate with this committee, and therefore we stand adjourned.
Mr. Chairman, I have a statement. I have a procedural question, Mr. Chairman. Mr. Chairman, I have a procedural question. Mr. Chairman, you cannot run a committee like this. You just cannot do this. We're better than that as a country. We're better than that as a committee. I have asked for a few minutes to ask a procedural. What's the big deal? May I ask my question? May I state my statement?
You're all free to leave. We've adjourned, but the gentleman may ask his question.
Thank you very much. Mr. Chairman, I have one procedural question, and it goes to trying to help you get the information, by the way, that you just asked.
What is your question?
Let me say what I have to say. I've listened to you for the last 15 or 20 minutes. Let me say what I have to say. Mr. Chairman, I have one procedural question.
Ms. Lerner, you're released. You may.
But first, I would like to use my time to make some brief points. For the past year, the central Republican accusation in this investigation.
We're adjourned. Close it down.
Political collusion directed by.
On the left-hand side of your screen, let me just tell our viewers what you're seeing there. Darrell Issa is standing, and he says, "We're adjourned." And Elijah Cummings, who's the ranking Democrat, says, "No, we're not."
Of the United States of America. I am tired of this.
Well,
we have members over here, each who represent 700,000 people. You cannot just have a one-sided investigation. There is absolutely something wrong with that, and it is absolutely un-American.
Here, here.
we had a hearing. It was adjourned. I gave you an opportunity to ask a question. You have no question.
I do have a question.
I gave you an opportunity to speak.
Chairman, what are you hiding?
He's taking the fifth, Elijah.
He continued to stream on Sunday when he happened.
All right. You're not getting clear audio because it would appear as though Darrell Issa, the chairman of the committee, shut off the audio. So what you're getting is sort of ambient sound from the cameras in the room. It's very hard to understand what Elijah Cummings is saying, but clearly he is quite upset about what has unfolded here. Again, you're just now joining us. Lois Lerner appeared for the second time before the House Oversight Committee, and in response to questions from the chairman, invoked her Fifth Amendment right against self-incrimination. You know, go ahead, Martha.
Thank you very much, Mr. Chairman. And I, too, agree that this is a tragic situation. But let's be clear. This is not just on the EPA. It's much bigger than that. And so I take a moment, first of all, to thank Leanne Walters, Professor Edwards, and to the people of Flint, many of whom have come here today. They're lined all outside these walls, unable to get in, and probably feeling left out. But they probably felt left out for a long time. And so, Mr. Chairman, I take this moment to thank you. You didn't have to do this. I asked you for a hearing, and you granted us 3 hearings. And I really appreciate that. You see, because I live in a neighborhood where lead is a problem. I'm very sensitive to this issue. Governor Snyder has been described as running the state of Michigan like a business. Well, what if this was a business? What if a CEO ran a company that sold toys laced with lead that children put in their mouths? What if those children were poisoned as a result? And what if that CEO ignored warnings for more than a year as those kids got sicker and sicker and sicker. There's no doubt in my mind that if a corporate CEO did what Governor Snyder's administration has done, he would be hauled up on criminal charges. The board of directors would throw him out, and the shareholders would revolt. This is similar to what is happening now to Governor Snyder. The special counsel for the state attorney general's office has launched an investigation. And he says, I didn't say this, he says, that state officials could face charges including breach of duty, gross negligence, or even manslaughter. Charges, he says, are, and I quote, not far-fetched, end of quote. On our committee, we've obtained documents showing that people all around the governor, including his chief of staff, were sounding the alarms, but he either ignored them or didn't hear them. So we're talking about quotes. Let's talk about them. In October 2014, the governor's top legal advisor had warned that Flint should, and I quote, get back on the Detroit system as a stopgap as soon as possible before this thing is too far out of control. End of quote. That's the chief of staff. In March of 2015, the governor's own chief of staff, now that was his legal advisor, but his chief of staff said in March of 2015, if we procrastinate any longer in doing something direct, we'll have real trouble, end of quote. That's from the chief of staff. And in July, his chief of staff again warned that Flint residents, and I quote, are concerned, and rightfully so, about the lead level studies they are receiving. They are basically getting blown off by us, end of quote. The document reveals failures at every level, led by Governor Snyder's hand-picked appointees, and the governor's fingerprints are all over this. His Department of Environmental Quality, his Department of Health and Human Services, his inner circle of top aides, his press staff, and his chief of staff, and of course the emergency managers the governor put in charge of Flint. There will now be an entire generation of children who suffer from brain damage, learning disabilities, and many other horrible effects of lead poisoning that were inflicted on them by Governor Snyder's administration. There'll be many children, Mr. Chairman, who will sit in the second and third grade and will not be able to read the words "see, spot, run," and won't know why. But the reason why is because there's lead in their veins. Now, Republicans are desperately trying to blame everything on the EPA. So let me say this. I agree that the EPA should have done more. They should have rushed in sooner to rescue the people of Michigan from Governor Snyder's vindictive administration and his utter incompetence at every level. Governor Snyder's administration had primary responsibility for enforcement under the Safe Drinking Water Act, not the EPA. Governor Snyder's administration chose to switch to the Flint River for a source of water, not the EPA. Governor Snyder's administration ignored warnings from the Flint Water Treatment Plant supervisor not to go forward with the switch, not the EPA. Governor Snyder's administration falsely told the city of Flint that corrosion control was unnecessary, not the EPA. Governor Snyder's administration delayed corrosion control for months and harmed thousands of additional people in the process, not the EPA. Governor Snyder's administration overruled the Flint City Council's vote to return to clean Detroit water, not the EPA, as I close. So yes, I agree. The EPA should have snatched control out of Governor Snyder's hands even sooner than they did. But Governor Snyder's administration caused this horrific disaster, and poison the children of Flint. On the governor's website, his motto is, and I quote, reinventing Michigan, getting it right, getting it done, end of quote. It's hard to imagine a more misleading slogan. It also says this, and I quote, we will learn from this experience, end of quote. And so, as I said earlier in the other hearing, these children, when we're dead and gone, these children will suffer for what we failed to do. And so, Mr. Chairman, as I've said to you before, we have to be the last line of defense. We have to be it, because generations yet unborn will suffer. But we've got to do everything in our power to mitigate that. I look forward to the hearing, and I yield back.
I want to make sure I understand exactly what you testified to on the issue of whether Secretary Clinton sent or received emails that were marked as classified. On Tuesday, you stated, and I quote, only a very small number of the emails containing classified information bore markings, and I emphasize, bore markings indicating the presence of classified information, end of quote. Republicans have pounced on this statement as evidence that Secretary Clinton lied. But today, we learned some significant new facts, and I hope the press listens to this. First, you clarified that you were talking about only 3 emails out of 30,000 your office reviewed. Is that right?
3, yes.
3 out of 30,000. Is that right?
Yes, at least 30,000.
At least 30,000. Second, you confirmed that these 3 emails were not properly marked as classified at the time based on federal guidelines and manuals. They did not have a classification header. They did not list the original classifier, the agency, office of origin, reason for classification, or date for declassification. Instead, these emails included only a single, quote, C, parenthesis, in parenthesis, and then end of quotation mark, for confidential on one paragraph lower down in the text. Is that right?
Correct.
Third, you testified that based on these facts, it would have been a, quote, reasonable inference for Secretary Clinton to, quote, immediately, end of quote, conclude that these emails were not, in fact, classified. So that was also critical new information. But there's one more critical fact, that these emails were not, in fact, and that is this, Director, and to the press, these emails were not, in fact, classified. The State Department explained to us yesterday, they reported that these emails are not classified and that including the little c on these emails was a result of a human error. The bottom line is that those little c's should not have been on those documents because they were not, in fact, classified. When Representative Watson Coleman asked you a few minutes ago about this, you testified that you had not been informed, and I understand that. I'm not beating up on you, I promise you. But can you tell us why, Director Comey? Because I want, because the Republicans are pouncing saying that the Secretary lied, and so I want to make sure we're clear on this. Can you tell us why, Director Comey, did you consult, and we're just curious, did you consult with the State Department about these 3 emails out of the more than 30,000? Did this just not come up? What happened there?
Yeah, I'm not remembering for sure while I'm here. I'm highly confident we consulted with them and got their view on it. I don't know about what happened yesterday. Maybe that their view has changed or they found things out that we didn't know. But I'm highly confident we consulted with them about it.
So this is totally different than what we understood yesterday. Today we learned that these emails were not, in fact, classified. They should not have been included. They should have not included those stray markings. They were not properly marked as classified, and the director of the FBI believes it was reasonable for Secretary Clinton to assume that these documents were not classified. This is similar to what is happening now to Governor Snyder. The special counsel for the state attorney general's office has launched an investigation. And he says, I didn't say this, he says, that state officials could face charges including breach of duty, gross negligence, or even manslaughter. Charges, he says, are, and I quote, not far-fetched, end of quote. On our committee, we've obtained documents showing that people all around the governor, including his chief of staff, were sounding the alarms, but he either ignored them or didn't hear them. So we're talking about quotes. Let's talk about them. In October 2014, the governor's top legal advisor had warned that Flint should, and I quote, get back on the Detroit system as a stopgap as soon as possible before this thing is too far out of control. End of quote. That's the chief of staff. In March of 2015, the governor's own chief of staff, no, that was his legal advisor, but his chief of staff said in March of 2015, if we procrastinate any longer in doing something direct, we'll have real trouble, end of quote. That's from the chief of staff. And in July, his chief of staff again warned that Flint residents, and I quote, are concerned, and rightfully so, about the lead level studies they are receiving. They are basically getting blown off by us, end of quote. The document reveals failures at every level, led by Governor Snyder's hand-picked appointees, and the governor's fingerprints are all over this. His Department of Environmental Quality, his Department of Health and Human Services, his inner circle of top aides, his press staff, and his chief of staff, and of course the emergency managers the governor put in charge of Flint. There will now be an entire generation of children who suffer from brain damage, learning disabilities, and many other horrible effects of lead poisoning that were inflicted on them by Governor Snyder's administration. There'll be many children, Mr. Chairman, who will sit in the second and third grade and will not be able to read the words "see, spot, run," and won't know why. But the reason why is because there's lead in their veins. Now, Republicans are desperately trying to blame everything on the EPA. So let me say this. I agree that the EPA should have done more. They should have rushed in sooner to rescue the people of Michigan from Governor Snyder's vindictive administration and his utter incompetence at every level. Governor Snyder's administration had primary responsibility for enforcement under the Safe Drinking Water Act, not the EPA. Governor Snyder's administration chose to switch to the Flint River for a source of water, not the EPA. Governor Snyder's administration ignored warnings from the Flint Water Treatment Plant supervisor not to go forward with the switch, not the EPA. Governor Snyder's administration falsely told the city of Flint that corrosion control was unnecessary, not the EPA. Governor Snyder's administration delayed corrosion control for months and harmed thousands of additional people in the process, not the EPA. Governor Snyder's administration overruled the Flint City Council's vote to return to clean Detroit water, not the EPA, as I close. So yes, I agree. The EPA should have snatched control out of Governor Snyder's hands even sooner than they did. But Governor Snyder's administration caused this horrific disaster and poisoned the children of Flint. On the governor's website, his motto is, and I quote, reinventing Michigan, getting it right, getting it done, end of quote. It's hard to imagine a more misleading slogan. It also says this, and I quote, We will learn from this experience, end of quote. And so, as I said earlier in the other hearing, these children, when we're dead and gone, these children will suffer for what we failed to do. And so, Mr. Chairman, as I've said to you before, we have to be the last line of defense. We have to be it, because generations yet unborn will suffer. But we've got to do everything in our power to mitigate that. I look forward to the hearing.